All right. Earlier in this case, defendant entered a plea of
Aggravated assault, second-degree felony. Not exactly a light charge, but here's where it gets real. The defendant has already pled guilty. So now, it's all about what comes next. 10 years behind bars. Or a second chance on probation. Stick around, this is going to get complicated.
guilty to aggravated assault, a second-degree felony, and a pre-sentence report has been prepared. Have the parties had an opportunity to review it, and are there any corrections or changes to it?
Judge, I've received and reviewed it, and we don't have any changes from the judge.
And state.
Same, Your Honor.
All right, it will be made part of the record for all purposes. And the agreement here is a cap of 10 years imprisonment. So we are looking at two options.
Legal breakdown. Regular probation is off the table due to the case's severity, so it's either prison time or deferred adjudication. That's essentially a second chance without a formal conviction, but it comes with strings attached. Would you risk it?
On the second-degree felony, no less than 2 nor more than 10 years confinement in prison. Also, the defendant could be placed on deferred or unadjudicated probation.
Yes,
I don't believe regular probation
Is
is an option under law because of the circumstances of this case. All right. Mr. Lewis, you may go forward.
Judge, this situation, fortunately, it wasn't worse than what it was. Definitely. But it was a situation where my client has been dealing with some harassment and bullying, dealing with the complainant, her friends for a long time at this period. This confrontation here was pretty much her breaking point at that moment. It was totally out of character for her. Not something that, in normal, regular circumstances, she would have acted in that way in any way. It was a situation where, and when I say prior bullying and harassing information, I'm talking about from people coming, breaking or shooting the windows at her home to.
We're talking full-blown online warfare here. Screenshots, harassment, social media taunts. While out on bond, this isn't just courtroom drama. It's cyberbullying meets criminal court. Can retaliation ever justify a violent reaction? Drop your take below.
Very severe or serious circumstances that these things have been going on, and actually have been even still dealing with some of it after this case happened, while she's been on bond, to the point of people associated with the complainant or either screen recording or whatever, sometimes docket, and would post these things on social media in an effort to taunt her while this case has been going on. And there was even a situation where she's had people try to confront her. Now, I will say my client and her actions since then, she's done everything she can on her end to try to avoid these situations at all costs. She had moved to a new location that is a safe place for her and her child. That's undisclosed as far as she knows, as far as people associated with the complainant. She has been haven't had any issues while she's on bond as far as attending court or doing anything of that nature, other than I believe she had one situation where when she was in the hospital having a child, she had to miss court, but they had medical issues at that time. She has a 4-month-old child this time to raise and take care of. And as you see in the PSI, she has, until the pregnancy, maintained a stable work history, as well as going to school to help try to further her career. So she is making positive changes for herself, and I won't even say changes, staying on that same track. So I believe her future is one that's definitely salvageable in this circumstance. I think there's plenty of vehicles available through the probation department that can help Ms. Money as far as move forward, as well as still be able to serve out any punishment or sentence that court deems necessary. I know there's restitution involved in this case that my client, through with her schooling and her career moving forward, I think she'll be able to take care of that and do what she can to make the plaintiff whole in that circumstance. There are other conditions, of course, that's available to the court, as well as county jail time or...
This is a major emotional turn. The defense is painting a picture of a young woman trying to turn her life around, raise a child, and stay safe. But the court isn't just looking at what she's doing now, it's about what she did then. And that next part, it gets heavy.
Anything of that nature to satisfy any concern the court may have of her actually serving some time in jail is necessary. And I know as far as her version of everything, she talks about, concerning the car running her over or running them over. If the evidence doesn't totally support that, but of course, what she may have been thinking of going through some of her friends, at that time could have been it, but maybe not enough to rise to the self-defense claim that she could have maybe used that trial, liable to use that trial. So we are asking that the court seriously consider placing her on deferred adjudication. I think she's the type of candidate that will be able to make the most of that circumstance and will be able to be successful and move forward. Also, I would like to, she did want me to let the court know she wanted the opportunity to address the court and let you know how she would, her plans for the future, as well as her being able to be, how she feels for it being able to be successful on the deferred judge.
Yeah.
I just want to let the court know that I take full accountability of what happened that day. And I am very, I changed my life all the way around. I don't hang around the same people. I have a child now. I'm in school. Everything around me is positive now.
Did you have a child then on March 30th?
Yeah.
You didn't have any? Were you pregnant then?
No, I got pregnant after.
Okay. Go ahead.
And it was out in a kind of a hard situation, but I take full accountability of everything that happened that day. I wish everything was different, and I wish I could take it back, but it's you can't take it back. It happened, and I take accountability of what happened.
What caused you to act this way?
I want to say I was just at a breaking point, really, to the point where it was so much that happened to me, with these people. So it's a breaking point thing. And I was kind of in the fear of my life, and they probably was in the fear of their life as well, too.
How were you in the fear of your life? Can you explain that? Because only one person was shot more than once, right?
At the time,
It was you doing the shooting.
when it was going on, before the shooting happened, she was kind of in her vehicle trying to run me over. It was a thing like that. So I was basically not defending myself, but at the same time trying to protect myself and who I was with. And basically, I guess she was trying to protect herself and who she was with.
Okay. The police came out and investigated this, didn't they?
Mm-hmm. Basically.
Okay. So after their investigation, did they charge the other people with attempting to harm you in some way, attempting to kill you, or attempting to assault you with their car? No?
Other charges.
Does that no?
No.
You have to speak out. So
No, sir.
why do you think that? Or did the police fail in their job, or do you think they investigated this thoroughly?
In my opinion,
Mm-hmm.
I really don't think that it was, because when they called me, I was actually I was out of town when they called me. But I told them when I came, when I was coming back, and they were supposed to came out and fully investigate with me to take my side on what happened that day, and they didn't.
The judge drops a reality bomb. Taking responsibility matters, but so does the gravity of the crime. Shooting someone 4 times, that's not a misunderstanding. That's a moment that changes lives. Would accountability be enough if you were the victim?
Well, they investigated it, and they did not elect to file charges against the other people who you say were attempting to harm or kill you with a car.
Correct.
And you were defending yourself. Self-defense. That's what it seems that you're saying here. You're not admitting. You're saying that they were trying to harm you, and you were defending yourself by protecting yourself with a firearm, and shot somebody 3 times, right?
Yes, sir.
The right shoulder blade, left ankle, left forearm, and and upper lip, sorry, 4 times. But upon their investigation of this, they did not charge the other people with anything victimizing you, just you.
Correct.
Which this leads anybody reading this to believe, according to their investigation, you just lost your composure and decided to use a file, which was the wrong thing to do.
Was.
Well, you got to pay a price. Okay. Well, too many people come in here and just there's always somebody else's fault, and you're taking responsibility for your actions.
Correct.
But you have a lot to lose here. We're looking. This could have been up to 20 years in prison. You understand that? And you got a child,
Right.
and that you got to take care of, and a family that's, I guess, you're growing, and and you don't have a criminal history.
Wow.
What? This isn't the first time somebody is before this court charged with a serious crime who believed that a lot of it had to do with being provoked. But yet, words, threats, those things are just under the law aren't enough to get in a car, get a gun and shoot somebody 4 times. And the situation about you were defending yourself, truly, Mr. Lewis is a very wise man, and he evaluates cases. And if he felt like there was something really to substantiate that, we would be having a trial. Like we have 600 trials in this court. I mean, we try cases, and we're not afraid to try cases to get the facts out, get the truth, get responsibility placed on the people who justly deserve the responsibility. And this is one of those things where I believe we have a misunderstanding, to say the least. But you got to have the strength of character just to move on and be the better person. Because what happened is at the worst, at the best for you, is they dragged you down to their level, and then you pulled a gun, and then you get in trouble. And but once again, nothing shows that there's nothing here that reflects you had to use that firearm to defend yourself. You were in imminent danger of death or serious bodily injury from being run over by a car. Nothing shows that. And if it were, we'd be here trying this case, and that would be a defense. And
Here's the twist. The victim, who was shot 4 times, hasn't said a word in court. No victim impact statement. No direct testimony. Is that silence a form of healing, fear, or something else entirely? This ending leaves more questions than answers.
But you accepted responsibility under these terms, under this set of circumstances, and there are no objections in this pre-sentence report?
No, sir.
Okay, and it's made a part of the record for all purposes. What says the state?
Judge, I do note one error in the PSI. When you look underneath the adult felony court history, the deadly conduct, which I am dismissing as part of this plea agreement, comes from the same date and offense. For some reason, there's a different date there, so that needs to be corrected to where it's March 30th of 2024.
Okay, so it was this other charge arose, and I guess this is 24 CR 1105.
Right,
This arose from the same episode?
Yes, sir.
So